front end of this, maybe to help your oral argument one way or another. One is that once upon a time, not that many years ago, Brandon Christian was my staff attorney. And the Minsky case came into my office while he was still at my office. The heavy lifting on the case, however, occurred after he left. And so the content of that opinion is something that he doesn't have any probably more understanding of than you do. But I thought you at least ought to know that he had been in my office at the time the thing first arrived in my office. The second thing I want to point out to you is that neither one of you have done any briefing on United States versus Jones, which is the U.S. Supreme Court case on GPS on a motor vehicle, or U.S. or Florida versus Jardines, which is the what I'll call the dog knock and talk at the House. And in both of those cases, especially Justice Scalia seems to revive the trespass analysis for Fourth Amendment. Whether he did it for 5 justices may be debatable, but when Minsky was written, I'll just tell you right up front that I thought Katz had pretty well removed the trespass analysis from the Fourth Amendment. And so the discussions on trespass in the Minsky, as the author of the opinion, I'll tell you, I think are suspect at this point in time, and that may help both of you as you do your oral argument. So with that, I'm going to turn it over to you.
Well, thank you very much, Your Honor, and may it please the Court. Michael Minardi on behalf of Mr. Robinson, and the first issue I'm going to address today actually would be the constitutional basis of cannabis as a Schedule I substance. That was challenged below, and we did file a motion to dismiss on that. It was denied by the Court. The issue in that case, Judge, number one, is an issue of statutory construction. A Schedule I substance is defined as a substance that has a high potential for abuse and has no currently accepted medical use and treatment in the United States, and its use under medical supervision does not meet accepted safety standards. We know today that half of this country, almost half of this country, 24 states, plus Washington, D.C., plus now the U.S. territory of Guam, all allow the medical use of cannabis by its citizens. Why? Mainly because of the National Institute of Health and their Institute of Medicine report back in 1999. Each of the statutes, and I cited in the binder in the appendix that was provided and is part of the record on appeal, have determined that cannabis, based on those statutes, does have medical efficacy for certain illnesses. Currently today, 86% of Americans support medical cannabis, and 58% of Floridians in this past vote clearly showed their support for medical cannabis, although it did not pass with 60%. It shows that it's currently accepted in the United States, not only by states and legislators across this country, but by the people of this country.
But the question here isn't, you're not in front of the legislature. Maybe the legislature can take it out of this chapter if it wants to, this next session, but do we have the constitutional power at this point in time to take it out ourselves?
I absolutely agree and believe that you do. As in Hamilton and Watkins, which are both cases that denied the challenge to the constitutionality of this statute, they basically said that there was a rational basis test that this court has to do. It has to make a determination as to whether or not there continues to be a rational basis to have cannabis as a Schedule I substance.
Do all these states you're talking about, they let everybody just manufacture their own pharmaceutical cannabis, or do they have regulated systems? I had the impression that there was a heavily regulated manufacturing system.
That depends on the state. It is varied state by state. Unlike alcohol originally and like alcohol is now, each state is allowed to establish their own laws, and that's what the federal government has allowed to happen.
Because this isn't a possession case. This is a manufacturing. I always thought that term was odd for marijuana, but this
Correct.
is basically you're growing marijuana.
It is. It's a cultivation, and I would say that in most intents and purposes, it is in fact a possession case. He was possessing it for his own medical purposes. This is a gentleman who did have a medical condition and was using it and choosing it over more deadly opiates. But the issue is whether or not there continues to be a rational basis. And this court, as it knows, has an obligation and duty. And that's why our Constitution and Declaration of Independence was originally established with 3 branches of government as a checks and balance system. And that's what this court...
Marijuana is still a federal offense, right?
That is correct.
So is it unconstitutional at the federal level as well then?
Well, that actually is being challenged right now in the Eastern District of California, I believe. They have had oral arguments on that case for the past couple of weeks, challenging very much the same thing that I'm challenging here and have been doing for some time in these courts in Florida, because the facts and the evidence and the medical science no longer supports cannabis as a Schedule I substance. The government's own reports, the Institute of Medicine report, Judge Young's DEA report, which is in the materials as well, all support that cannabis is much safer than any other Schedule I substance, Schedule II substance, and Marinol, which is a derivative THC, the same exact type of compound that is in cannabis in the plant, is a Schedule III substance. So to continue to say that cannabis is a Schedule I substance, and now this is statutory construction argument in combination with the rational basis, because the court has to look at the statutory construction, the wording in the statute, in order to determine whether or not there's a rational basis for it to continue to fit into that statute. Barusa, which is a dissenting opinion from 1978, believed then, the judge believed then, I believe it was Justice Adkins, believed then that there was sufficient evidence to say that cannabis doesn't belong in a Schedule I substance. Now, why can this be revisited today? Because since the last time that this issue has been dealt with or determined by any sort of appellate or the Supreme Court of Florida, there's been 24 states, over 20,000 studies, and over 500,000 people in this country currently are using medical cannabis under doctor supervision safely in these medical states.
And articulate for me the reasoning would use to write to say that it was unconstitutional. It's not an equal protection issue, is it?
It is. It's a combination of an equal protection brings about the rational basis test. So in any opinion that would be written would be based on the fact that there continues, based on science and medication, and this isn't just me, the Attorney General has said this recently, the President has said this recently, the American Medical Association believes that this should be rescheduled. There's really nobody, in Watkins' case, the 1997 case, which is different.
Does it come out of the schedule or does it just get moved from one spot to another spot?
Well, at this point, I think it should be unscheduled until the legislature can do the scientific or order the legislature unschedule it, order some sort of scientific and medical evidence to show what schedule it should fit in. Now, Obama, president, recently addressed it and said that it was no different than alcohol or tobacco. And these are two drugs that you can go and buy in any corner store. Alcohol kills about 80,000 people a year, and tobacco kills about 400,000. It's almost 500,000 people a year that those substances are killing, but yet they're legal and widely available for use. Cannabis, in over 5,000 years, has no reported deaths as a single cause of cannabis. If you go to Judge Young's opinion, and this has been considered in...
Counsel, can I jump in just for a minute? You use your time any way you want, but I find the suppression issue to be a little bit more intriguing than the one you're arguing. And okay. I think I have a pretty good handle on the one you're arguing, and you've laid it out, but you're running out of time, but you use it any way you want.
Well, and if I jump over to the suppression issue, and I just wanted to put the information on the record, this is a rational basis test, that there really continues to be no rational basis for cannabis as a Schedule I substance. In regards to the trespass issue, and the state brought up and pointed in their brief the Bainter v. State. In that case, the court asked the question whether or not the defendant established a reasonable expectation of privacy that the court and society would recognize. Now, in this case, Mr. Robinson had a fenced-in property. It was made clear that that fenced-in property had a no trespassing sign, beware of dog sign on it, and was closed by a gate. It wasn't for animals. The officers both testified and agreed that the animals all had separate pens. Now, the officers decided, the mailbox was on the outside, and we had testimony from the defendant's daughter that she always knocked or honked or called ahead in order for him to come out and open the gate. She never opened the gate. As far as she knows, mail carriers and stuff posted the mail and put it outside the gate, and no one entered the gate without permission or without Mr. Robinson, even his friends and visitors. Now, in Bainter v. State, and in that court, they did find that the defendant established a reasonable expectation of privacy that society would recognize, and that is a 5th DCA case. And in that case, just like in this case, they were acting on an anonymous tip. There was a 6-foot chain link fence around the property. It had a chain link push gate at the entry and the roadway, and there was no trespassing sign. and the police opened the gate and drove into the yard. The defendant left the gate unlocked and opened on this day that these cops allegedly were there. Totally different than in this case, in Mr. Robinson's case. The gate was closed.
How far back is the house in this case?
I believe it's about a couple 100 feet.
Is it visible from the road at least?
It is visible from the road. They could see the road and the pens from the rear, from the roadway. And I understand in the state, and Judge brought that up in the other court, and I don't think any of the case law establishes that basically we have to have a militarized zone in order to attempt to exclude people. The question is, one, whether or not anybody, a reasonable expectation of privacy, whether or not you or I, by putting up a no trespassing sign, would assume that people are not going to.
Yeah, because you've got a 6-foot fence all the way around this property.
Correct.
And no trespassing signs on it.
Correct.
And the gate is closed but not locked. Is that the status of this?
That is correct. And it had a beware of dog sign on it as well. The daughter testified that there was a chain around the fence that was closing it. It wasn't a lock chain, but it was just a chain to hold the fence in. The cops don't remember that being there present.
So your primary position here is that these additional measures take this case outside of the Minsky rule, is that right?
Absolutely, absolutely, Your Honor. And I believe in Minsky they even say, a litany of things, but if the defendant, right, he said,
Forgot that.
that, if the person had created things such as, and you give a list of certain different things that a person would do in order to establish a reasonable expectation of privacy. It's my perspective that the judge in the lower court believed that sort of all of those things needed to be in effect in order to establish that reasonable expectation of privacy. Since then, we have had the Bainter case, the Powell case, the Federer case, and the Ferreira case, which all basically support the position that taking steps to keep uninvited visitors out by fencing the property and posting a gate around the property creates a reasonable expectation of privacy, and that was the Ferreira case. Federer is basically the same thing, and the question is the subjective intent in many ways of the person. If you or I or anybody who's not law enforcement walked onto someone's property with a no trespassing sign, we're getting arrested. That's what the law says. And there's, I think in the Minsky that you went into the privacy rights, and an invitationee or someone invited onto the property. Now, a no trespassing sign, as stated in Bainter and as stated in Powell v. State, would effectively negate any invitee's automatic, right to go onto the property, just like a solicitor wouldn't be able to go onto a property, just like a salesman shouldn't go onto a property with a no trespassing sign. Neither should the officer, because that invitation has been withdrawn by the owner of the property. And Mr. Robinson clearly put forth his expectation of privacy and his intent for people not to enter his lawn by putting up that no trespassing sign and beware of dog sign.
How, if at all, does the fact of the plants being burned, how does that enter into the analysis?
I don't think it does. The anonymous tip never said one thing about burning plants or anything like that. Granted, Mr. Robinson admitted after it, but the anonymous tip said that they were hiding plants. The helicopter never saw them. So basically, this whole illegal search, what I would say, entering onto the property was based on an anonymous tip.
Did the state argue that there were exigent circumstances or were allowed to get in without a warrant?
On the lower court, no, they did not. I know that it was brought up by the appellate brief, but it was not argued in the lower court, and there was absolutely no indication of that. The officers testified that they couldn't smell burning cannabis coming from there. They didn't see the fire in the fire pit or anything of that nature. So I don't believe that there was any situation of exigent circumstances.
And I know you're interested in the issues that you started with first, but if the suppression issue is dispositive and we don't have to therefore hold an entire statute unconstitutional, we pretty much have to go to the suppression issue first, don't we?
Absolutely, and I agree with that. And
it is, and I'm assuming your position is it's a dispositive motion to suppress.
Absolutely, absolutely. It is a dispositive motion to suppress. The court and the state agreed to that below. They would have never been onto the property. They would have never searched the property. They would have never, made contact. And the cases do state that, that illegal initial search would vitiate any sort of consent afterwards because of the initial legal taint. So I'll reserve the rest for
Okay, thank you. Mr. Christian?
May it please the court, Brandon Christian for the state of Florida. So the appellant in this case has entered an open plea of no contest to a charge of manufacturing marijuana. He was placed on the 3 years probation and then adjudication was withheld. Just regarding the third issue that the appellant has raised, and that's the constitutionality of Florida's laws prohibiting marijuana. Section 893.13 makes it unlawful to sell, manufacture, or deliver certain substances. And then Section 893.13, subsection 1C7, lists cannabis as one of those substances, and specifically as a Schedule I controlled substance. So the appellant's argument on this issue is basically a disagreement with the legislature's determination that cannabis is a Schedule I controlled substance. Again, it's a disagreement with a legislative decision. If he wants to take that up with the legislature, you know, he's free to contact his congressman or to exercise his right to vote or to do any of the other things that a citizen in a democracy can do to exercise their political will. But he's not free to smoke marijuana and to grow marijuana on his property. So again, that's the state's position regarding that issue. He also raised, in issues 2 and 4, he's raised challenges regarding the trial court's rulings on an evidentiary issue and then also regarding a medical necessity defense. Florida Rule of Appellate Procedure 9.140 does not permit him to raise those issues after he's entered an open plea of no contest. And there's a variety of practical reasons why he can't do that. And specifically, at this juncture, there wouldn't be any expectation that this case would ever go to trial. So the court's ruling or any kind of opinion on that issue would be basically an advisory opinion on a case that certainly neither of the parties really ever expect to go to trial. So moving on to the first issue that Mr. Robinson's raised, this is a challenge of the trial court's denial of his motion to suppress. He carried the burden, at least the initial burden, of establishing that he had a reasonable expectation of privacy on the issue. So the testimony and the evidence that was presented in the trial court on this came through Detective Capo, and then it also came through Mr. Robinson's stepdaughter. And so Detective Capo's testimony was that he was participating in a marijuana eradication operation. He said that he received, the sheriff's office received a tip that was conveyed to him. He acknowledged that the tip was anonymous. The caller wished to remain anonymous. The tip was that a subject at the residence now associated with appellant's address was disposing or was growing approximately 40 marijuana plants and was attempting to dispose of them, and that they were doing so having observed the sheriff's office helicopter. So Detective Capo with 2 other detectives responded at about 12:30 in the afternoon. They come to the property. Detective Capo's testimony on the issue is that this was a very rural area. He characterized the property as being about 3 acres. It's surrounded by a livestock type fence is the way that he characterized it. He says that there were farm animals present on the property. As far as the gate itself goes, he says this is a metal gate with a hinge, that no lock was on the gate. He did not testify regarding a chain. I realized that the daughter testified after the fact that a chain was perhaps present at some later point, but there wasn't any testimony that there was actually a chain present at the time. So the trial court's finding on the issue was that no lock was present and that all that a person would have to do to open the gate would be just to push the gate open.
But where was I guess there were both no trespass and bad dog signs.
That's correct. And that was also a finding by the trial court. So the state is not disputing that the signs were present at the time that the officers...
Were they at or around the gate? Is that...
The testimony is not specific, but yes, they were at or around the gate. So they would have been visible to someone who was present at the gate. Detective Capo didn't recall the signs, but again, the state's not disputing that the signs were present at the property and at the gate. So Detective Capo opens the gate and the officer
We do have a
proceeds.
mailbox, and the mailbox is out at the road in this case.
Detective Capo, I believe, was asked about that. In his testimony, he wasn't sure, but he recalled that he thought that the mailbox was present outside the gate.
I've seen a photograph in this record that has a very visible mailbox. I haven't studied the photographs hard, but I was looking for a mailbox. Yeah.
Right. And I think that the photographs were offered through the testimony of the daughter. Part of the problem with those is I don't believe that detectives took any photographs of the scene, so any photographs that were offered were taken after the fact. And, again, they were offered through the testimony of the daughter. So, I mean, just to clarify how the photos came in, that was where they came from, and they would have been taken not on the day of the offense, but at some later point in time, presumably after Mr. Robinson was arrested.
Was there any evidence of an actual bad dog, out of curiosity?
No.
It was a friendly dog.
Unlike Minsky, we don't know whether the dogs were friendly or bad. So,
wouldn't a closed gate with a no trespass sign and a beware of dog sign, wouldn't you have to say that's indicia that presence on the property is unwelcome?
Those are
What else would I guess you're hanging your whole case on the lack of a lock? Is that the only other thing? Well, what else can they do?
Under the circumstances, the state's position is that we can't consider any of these factors in isolation, that we would look into them all together. So a no trespassing sign on a gate on a large property in a rural area, I would suggest that it means something different if the gate's locked or not locked. I think that's a significant factor in a rural area where you have farm animals on the property. I mean, each of the factors we look at, they're not dispositive of a person's intention to keep people off the property. So the gate, there's testimony that was, not the gate, but the fence itself is there at least to keep farm animals on the property. It's a large property. In terms of the gate, it's not locked. It's not secured in any way, so all that a person has to do is push the gate open. The no trespassing sign, it can mean something different perhaps depending on if someone is there at the property at the time or if they're not there at the property. I think it's reasonable to conclude that he may have had this on the fence. If he's not home, obviously he doesn't want people to come on the property perhaps if he's not home. I think that these factors can all go both ways.
The only thing that gives you a reasonable expectation of privacy then in a rural spot in America these days is a padlock on your gate?
I don't think that's the only thing, but I think combined with the other circumstances.
What else can you buy at a Home Depot other than no trespass?
A sign that says, and I really mean it?
Sure. Just by comparison, in Bainter, the defendant had barbed wire on top of his property. I think that's, not on top of the property, but on top of the fence itself. And I think that's a very clear indication of an intention to keep people outside of the fence. A lock would be a helpful factor. Obviously, the sign is an indicator, but again, it can't be considered in isolation in the context. And I do think that the expectation would vary, and whether society is going to recognize that expectation is going to vary depending on whether we're talking about a more rural property or, there are cases involving open fields on the one extreme, and then the other extreme would be, a bungalow in Hyde Park or an apartment. This case is somewhere in the middle of those two. It's also somewhere in the middle between Minsky and Bainter. Bainter, we had the fence with the barbed wire on it. There was also testimony presented regarding the fact that a UPS driver would leave packages outside the gate. Here we don't know whether private or public carriers would leave packages outside the gate or whether they would have entered through, or, for instance, what would a cable person or
Is like a sidewalk or a path or anything that goes to the front door of this house?
No, there's no testimony. The only path is the driveway itself. And so Detective Capo, his testimony is that the gate was approximately perhaps wide enough for 2 cars to enter. I'm assuming that that's about how wide the driveway was. And so...
Were there actually farm animals in I guess I'll call it the front yard area of this?
The record doesn't indicate whether they were present within the main fence, or because there were also apparently other pens and so forth on the property. So
I mean, this is only like 3-4 acres, so you're not going to have a lot of farm animals unless you're raising pigs or something, I suppose.
Correct. And so, we don't know whether there were horse or things, roaming the property, or whether they were only present within the other pens. So Capo opens the gate, he proceeds in, and he's accompanied by 2 detectives. It's not relevant for this appeal, but they're wearing their sheriff's office vests, they have their firearms. So they then gain access to the property, and then Detective Capo says he was sitting in his car when he sees the appellant walking alongside the outside of the house, and so then the appellant, Mr. Robinson, comes up and they engage in a consensual encounter, and the appellant then, at Detective Capo's request, walks them around the property. It was at the point when Detective Capo spoke with the appellant that Capo says he could smell marijuana. Presumably that could be coming from whatever's burning in the pile. And again, as Mr. Minardi pointed out, the record doesn't indicate, was this pile burning or was the burning visible from the roadway? But Detective Capo did say that the burned pile was visible from the roadway. It's just the testimony is not specific about, were flames coming up and so forth. But again, those are the 2 circumstances. And the circumstances I'm relying on as far as exigent circumstances go are the tip itself, and then Detective Capo's testimony that from the roadway he can see a burn pit in the backyard. So his knowledge was that he has a subject who's trying to dispose of plants, and then also that there's a burn pile in the backyard. So
forensics can't take a burnt marijuana bush and say that the ashes are from a marijuana plant?
No testing, to my knowledge, and based on the record, there wasn't any testing done on any material that was left.
Because it's only an exigent circumstance if the burning will destroy the evidence. And it's never been my impression that with marijuana that burning it destroys the evidence.
I would submit that burning evidence is sufficient to establish an exigent circumstance. Whether there is trace material left over, I believe it would be enough for law enforcement to attempt to stop the destruction of the evidence based on the fact that it's being set on fire by a defendant or a subject.
Because my impression is the state takes the position that burnt marijuana inside a marijuana pipe makes it paraphernalia and possession of marijuana. I see that double count.
That's true,
100 times a year here.
I would assume, and I'm not a chemist, but I would assume that continuing to burn the trace amounts that are left in the pipe would also constitute destroying marijuana, if not using it at the same time. Okay. So again, just to reiterate, the circumstances that were presented, or the no trespassing signs, and that has to be considered in conjunction with the other circumstances, which is that the gate's unlocked, it's a livestock type fence, and it's on a property of about 3 acres. And so once Capo's walked around the property, he discovers the 2 marijuana plants, and then post Miranda, the defendant admits that he was trying to dispose of the marijuana plants in the burn pit in the backyard. Of course, that circumstance wasn't known to Detective Capo from the roadway, but it confirms the rationale that this is a defendant who's trying to dispose of the plants. Let's see. As far as the stepdaughter's testimony goes, again, I think it's distinguishable from Bainter. She's testifying to her own personal practice of coming to the property and honking her horn at the gate. She's not a common carrier. She's not either a private or a public service provider. So when asked, how often did she come to the property, she said that she did not come very often. The other problem with her testimony is that she didn't have any personal involvement in the case until after this defendant was arrested. So she knows that she's being, trying to provide testimony regarding a specific issue, I would submit that that would go to her credibility. Unless the panel has any further questions, the state would respectfully.
The exigent circumstances alone, the tip combined with the burn, would that justify the officer jumping over the fence or breaking a lock down had there been one?
Yes, I would submit that
even if the gate is locked, if it's padlocked, the evidence that we have in this case, in your view, would justify taking a crowbar, hacksaw, whatever, get that lock off of there, we got to get in there, these people are destroying evidence, and that's perfectly legal.
Yes, it would be an exception to his, assuming that he's established a Fourth Amendment right. I mean, those aren't the circumstances presented here, obviously, but if it's an exception here, I think it would function the same way as an exception based on other circumstances.
It's an exception, right? I mean,
right.
What about the fire constitutes illegal conduct? Because so far you are telling me that the only thing law enforcement corroborated is a non-criminal act, that a fire was burning, that there was no county ordinance prohibiting burning of debris or anything, that any officer had smelled marijuana. So that act alone, corroboration is of a non-criminal act. How does that corroborate the tip in any way?
I would submit that the burn pit that was visible from the road, accompanied by the anonymous tip that was provided, the anonymous tip was that someone was attempting to hide marijuana plants. So then coupled with the burn pit, I think a reasonable conclusion would be that the officer would assume or would believe that the burn pit was being used to attempt to hide the marijuana plants. Whether the person is
one's hide and one's destroying, right?
Right. So I think that either hiding the evidence or destroying it would represent an exception to his Fourth Amendment rights. And also on the exigent circumstances issue, I mean, the case law provides for destruction of evidence is one exigent circumstance. The other one is when the subject is aware of law enforcement being in pursuit or being on their trail. And that's another thing that the tip was clear that he's doing this in response to observing a law enforcement helicopter overhead. So I think it's reasonable to an officer who's arriving at this situation to think that, well, this is a burn pit, it might be being used for this particular purpose. So unless the court has any further questions, the state would ask that the court affirm Mr. Robinson's judgment of conviction for cultivating marijuana.
Okay, thank you. Mr. Minardi?
Yes, Your Honor, thank you. First, and I think the anonymous tip thing is very important as far as the exigent circumstances. It is an anonymous tip. It gives absolutely no facts except this guy saw a helicopter and he's trying to hide something. It doesn't say anything about the basis of knowledge of where this tip came from, how this person knew about it, and the cops don't do anything to corroborate the fact that this guy actually has cannabis. He could have been burning anything. Exactly. Totally innocent conduct. Going back to that, and you do have the pictures, they have been submitted in supplemental discovery. I would state that the no trespassing sign is literally within a foot or 2 feet of the lock on the gate.
Yeah, let me ask you just a little bit about the photographs. Were they used at the suppression hearing?
Correct.
Okay, were they introduced into evidence?
Yes.
Okay.
Yes, they absolutely were. And also, it clearly, there's a picture that clearly shows the mailbox facing the outside of the fence where the Maryland postal carrier could go over it. Now, the court brought up Minsky, and one of the important things that I argued below as to why Minsky supported our case is basically the first paragraph. The dispositive issue in this case is whether a law enforcement officer may open a closed but unlocked driveway gate on a rural suburban acreage that is completely surrounded by a chain link fence in order to walk to the front door. And this court said in that first paragraph of part of the opinion, it says that at least in the absence of a no trespassing sign or a sign similar warning that the fence and the gate are intended to keep people out rather than keep animals in, we conclude that the officer may enter for a limited purpose. Now, obviously, Minsky is distinguished. We clearly have a no trespassing sign. As far as the daughter, she testified she'd been going there for years. She had lived there at a period of time. She was very familiar with the property, and neither one of those signs ever changed. neither did the chain on the fence. Regardless of whether or not she went there every day, she was able to testify consistently that that had always been there. We go to Bainter, and I think the amazing thing about Bainter is, in that case, again, the defendant left the gate unlocked and opened when he was home, and that postal workers, if a signature were required, would go through the gate to his door, and when friends come over, the guy would leave the gate open. And the day that the cops went to the house on Bainter, the gate was open. The court in that case said that posting of signs and fencing of the entire property and a push gate at the entrance exhibited the defendant's actual expectation of privacy that society is prepared to recognize. The court specifically held neither the fact that the gate was open nor the occasional friends or service providers come onto the property negate the expectation of privacy. So even if Mr. Robinson had the gate open, if he still had the no trespassing sign on there and the beware of dog sign, and there was a dog on the property, absolutely, according to Bainter, he still established an expectation of privacy. That wasn't the case. The gate was clearly closed in this case, and the signs were clearly visible right in front of the officers. Now, with regards to the animals, I specifically asked the officers questions about that because I wanted to make sure I knew, based on the case law, that there was a difference between whether or not the fencing was to specifically keep the animals in or not. And the officer agreed, and I believe the daughter also testified, that all those animals were in individual pens in the back. And the officers could see this from the road, so they absolutely knew that this fence wasn't entirely just for the purpose of keeping animals in. But he had separate pens for each of his animals. Yes, he has pigs and cows. But that is not a distinguishing factor. That is a distinguishing factor from the other cases, and it clearly, and I asked those specific questions for those specific reasons because I knew that would be an issue. And all the officers agreed that those pens were individually gated. The pictures, I implore the court to look at them. Yes, you can see the property from the house, but the no trespassing sign is in big bold letters right on the front of the fence that no one can miss. When you see the color pictures, and I don't know if you got the color pictures, but you can see actually kind of the wear on the sign and the tags, which looks like it had been there for an extended period of time, consistent with the daughter's testimony. The judge did find the daughter credible regarding those statements and did find those as findings of facts, that those existed on the date that the officers went out there. So, Your Honors, I would ask the court to grant the motion to suppress and discharge. The other issues regarding, I agree, would be advisory. Mr. Robinson has in fact completed his probation. The court orally terminated him early. So, we don't want, obviously, it to be discharged and sent back for a new trial. So if there's any questions.
Thank you.
Thank you.